Okay, I'm ready. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up that right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf, or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand, please. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's get started with the ladies' side.
Mr. Barfield. Yeah, else to do.
Ma'am, you're charged with one count of giving a false name, address, or date of birth. The bond's going to be set at $2,000. Do you believe you can post that bond?
I can't.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, ma'am, you're free to go back.
Ms. Brown.
Ms. Brown, you charge one count of family violence battery. Bond's going to be set at $5,000. You're also charged with one count of aggravated assault, and bond is going to be denied on that offense at this time. You're going to have a preliminary hearing date set for December 8th at 8:30 in the morning, courtroom 201. And you're going to have a bond hearing date set for December 10th, 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So you said that I don't have no bond?
You have no bond.
Okay.
Okay, ma'am, you're free to go back.
Ms. Burton, it's coming up, Your Honor.
Okay. Ms. Burton, you're charged with one count of aggravated assault. Bond is going to be denied at this point. There's going to be a stay away provision on the bond, stay away from a Joel Simons. Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. And you're going to have a bond hearing date set for December 10th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working, ma'am?
No.
Okay. You qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Ms. Dukes,
How you doing?
I'm doing well, ma'am. You're charged with one count of terrorist threats or acts. This is being charged as a felony. Bond's going to be set at $5,000 on that charge. One count of simple assault. Bond's going to be set at $4,000, and one count of cruelty to children in the third degree, which is a misdemeanor. Bond's going to be set at $3,000. You're going to have a total bond set at $12,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Roy Homer. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. That date will get waived on out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You had a checkbox next to, or had a check to the question of, do you have a job? Are you currently working, man?
Yes, sir.
How much do you make per hour?
Not much, like $10.
Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Thank you.
LaRoe, LaRoe,
Good morning.
Good morning, ma'am. You're charged with one count of theft of services. This is being charged as a misdemeanor. Bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a preliminary hearing date set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
How much do you earn per hour or per month?
Around 11:50.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
You said the bond is $2,000?
Yes, ma'am.
Okay, now I don't have any question, that's all.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Russell,
Good morning.
Good morning, Ms. Russell, ma'am, you're charged with one count of terrorist threats or acts. This is being charged as a misdemeanor. Bond is going to be set at $4,000. Do you believe you can post that bond?
Yes, sir, I can.
There's going to be a stay away provision on the bond, a stay away from a Jasmine Evans. Do you understand that?
Yes, sir.
Your
I don't know who that is, but I understand.
Okay, that's the person, I believe, that works in the apartment complex.
Mm-hmm.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a court date in the mail.
Okay.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I don't.
Okay, ma'am, you're free to go back.
Thank you. Have a nice one.
You too.
Ms. Wheeler,
Good morning, Ms. Wheeler, ma'am, you're charged with one count of theft by shoplifting as a misdemeanor and forgery in the first degree as a felony. Bond's going to be set at $2,000 for the theft by shoplifting charge and $4,000 for the forgery in the first degree charge. So that's a total bond of $6,000. Do you believe you can post that bond, ma'am? Okay. Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. That date will be waived upon your ability to bond yourself out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back.
Okay, thank you.
Williams.
Good morning.
Good morning, Ms. Williams. Ma'am, you're charged with one count of failure to driving a vehicle without the headlights turned on. And you're charged with one count of driving a vehicle without a license. There's going to be a $500 bond set for the failure to have their headlights on and a $1,000 bond for the driving a vehicle without a license. That's a total bond of $1,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I don't know if I would, be approved. I'll make $25 an hour, but I don't work a lot of hours.
Okay, so ma'am, I need a simple yes or no.
No.
Okay, then you're free to go back.
That's gonna be all the females, Your Honor.
I have a Brianna Go Million as an add-on. And that was an add-on from this morning. What I'll do, let's see. I have an LE number for her. I don't have a cell location. The LE number is 219-8122. I'll switch over to the male side and allow you guys to go find Miss Go Million.
Yes, Your Honor.
and
Just be advised, I'm sorry, Your Honor, go ahead.
No, go ahead.
If she's in intake right now, it's gonna be a lengthy process, so she might need to be continued for tomorrow, but if she's down here, then I can pull her and we'll try to get her support, but I'll try to work on that right now.
The communication that I got from the clerk's office over in the jail was that she came in at midnight. And so I don't know where she's located. They asked if I would agree to add her on, and I agreed to it.
Okay,
So just do your best and just report back to me. And if she has to go on tomorrow, she has to go on tomorrow. I presume that you guys have been notified, but I guess you were not.
no, Your Honor, my apologies.
No problem. Okay, so
I'm gonna
just
work on it right now.
okay. Now I'll leave her off to the side, and we'll get started on the men's side.
All right, thank you, Your Honor.
Thank you. All right, let's switch over to the male side. Are you Mr. Aldrich? I'm sorry, Mr. Aldrich is going to be left to the end. Are you Mr. Colvin? Oh, it's muted, so we're gonna have to unmute the male side. Okay, are you Mr. Colvin?
Yes, sir.
Okay, sir, you're charged with one count of theft by taking a motor vehicle. Bond is going to be set at $10,000. You believe you can post that bond?
Yeah, yes, sir.
Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me? I'm sorry,
Sir.
you said no?
No, sir.
Okay, thank you, Mr. Colvin. Sir, you're free to go back. Are you Mr. Harris?
Sir.
Sir, you're charged with one count of criminal damage to property in the second degree is being written as a felony. Bond is going to be denied at this point on that charge. One count of family violence battery, bond is going to be set at $5,000. One count of aggravated assault with a deadly weapon, bond is going to be denied on that count. And one charge of cruelty to children in the third degree, the bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a Kenesha Moy. Do you understand that? Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
When would I get a bond for the felons? Do I have to go to the Superior Court to get a felon bond for the felons?
You're going to have a bond hearing date set for December 10th, currently at 8:30 in the morning, courtroom 201. Your lawyer can go to the district attorney's office and see if they're willing to consent to a bond. If they're willing to consent to a bond, then a judge will sign off on it. But from the allegations in this case, I'm not certain that they will consent to a bond in your case. All right. Is there any other questions, sir?
Well, no, sir. Thank you.
All right, you're free to go back. Mr. James?
Yes, sir. We can go back.
Sir, you're charged with one count of false imprisonment. Bond is going to be denied on that charge. One count of aggravated assault. Bond is going to be denied. One count of cruelty to children in the first degree. Bond is going to be denied. All of those are felony offenses. There's going to be a stay away provision on the bond to stay away from a Mariah Taylor. Do you understand that?
Sir.
Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. You're also going to have a bond hearing date set for December 10th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
All right, you do qualify, Mr. James. I'm going to set a bond. I'm sorry, I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay. Mr. McCray. Deputies, are you there?
Yes, I'm here, Your Honor.
Okay, Mr. McCray has a TPO, a protective order that has been issued. And my understanding from speaking to Ms. Mary this morning is that it has been communicated over to the sheriff's department or transmitted to the sheriff's department. He's charged with misdemeanor offenses here today, but before he's bonded out, we're going to need him to be served with that TPO order. Is that something that can be done?
Yes, Your Honor, I can do.
Okay. Mr. McCray, sir, you're charged with 3 misdemeanor offenses, 2 counts of terroristic threats or acts, and 1 count of simple assault. You're going to have a bond set at $4,000 for each one of these offenses. So there's going to be a bond set at $12,000. Do you believe you can post that bond?
No.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, TPO, I was just trying to figure out, I live in this, in the community that they, posted and everything, but I was just trying to figure out how is it actually supposed to be processed, because, they had sent me a copy themselves. I also didn't come up with anything with it,
How, okay, you gotta like put labels on things. How is what supposed to be served?
Well, the last case I was in here for, they dismissed the case, so I was trying to figure out how did they send a TPO against me if they had, dismissed the case, pretty much.
You said last year?
No, 2 weeks ago. 2 weeks ago, I just got out of here. And they just now gave me the TPO like yesterday.
Okay, so you have been served with the TPO.
Yeah, I've just been served with the TPO.
Yesterday.
Yeah.
Was that after you got into custody?
It was served to me right here on the property. Yeah.
Okay, so let's use less words and be more direct. After you got arrested, you got served with the TPO, yes or no?
Before I got arrested.
Yes or no?
Yeah.
Okay, so I was informed by my office, and I obviously didn't sit on that case or issue. So all I know is that there is a TPO, and it may have been an ex parte TPO. And just for your knowledge, an ex parte TPO is something that is temporary until there can be a hearing to determine whether the TPO should be issued. So it sounds like that is the circumstance that you find yourself in. And so there'll be a date set for there to be a hearing to determine whether the TPO should issue or not, the either 6 month, 12 month. Okay.
No.
Do you have any other questions, Mr. McCray? I'm sorry. You said no? Okay, sir, you're free to go back.
State your name.
You're Mr. Milner?
Sir.
Okay, sir, you charge one count of criminal trespass, damage to property. This is being written as a misdemeanor. Bond's going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a Lisa Williams. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Miller. Mr. Parks?
Yes, sir.
Sir, you're charged with one count of family violence, battery. Bond's going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Jasmine Sumlin. Do you understand that?
Sure.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
All right, you're close to the edge, sir, but I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, you're free to go back.
Sir.
Mr. Pickens?
Yes, sir.
Sir, you're also charged with one count of family violence battery. Bond is also going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on your bond to stay away from a Christopher Morgan. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, excuse me, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Pickens.
Your Honor,
Do you-
Yes, Your Honor.
Do you have Mr. Robinson there?
Yes, I was just about to tell you about him too.
Okay,
This is his second time here. I think he was here like 4 years ago, right?
Yes, sir.
So.
I heard you say this was his second time here, but I didn't really understand what you said after that.
He was here about 3 days ago.
Okay. I don't have his warrant information. And this is a preset bond at $500. So I just assumed that he had been bonded out. What I'll do is this, Mr. Robinson, you now have one charge of disorderly conduct and bond is set at $500. I'm going to request your warrant information so that I can review it.
What's the warrant information?
Meaning why you got arrested.
Oh, I got arrested?
Yeah, and I'm not asking you to comment on that at all.
Oh.
I would get a copy of the, in this case, it's what we call a warrantless arrest affidavit, and the number is 2021 WA 18286. And I will review it to determine whether you should be released or not.
Oh.
Now, when you were here before, do you recall what date? Was it like, what day, Friday, Saturday, Sunday?
What's the day is?
Today's Thursday.
Thursday, I think that was Tuesday.
Tuesday. Okay. So you appeared before, did you appear before me or Judge Knights?
That's a good question. I want to know who Judge Nice is.
He's a male, and he has a little bit more darker complexion than I do.
Yeah, that's right. That was all.
Okay. So I'll go back and I'm gonna try to find what happened on Thursday. And Miss Gomillion, stay there. I'm gonna come over to you next. Because if he placed a condition on your bond, and if this new arrest violates that condition, then you're gonna be in a potential no bond situation.
For me?
No, ma'am. I'm speaking to someone else. And so, Mr. Robinson, as it currently stands, you're gonna have a preliminary hearing date set for December 7th at 8:30 in the morning. Did Judge Knights appoint a lawyer to represent you?
Yes,
Okay, so I'll go back and I'll try to figure that information out, because if you already have a lawyer appointed to represent you, I don't need to appoint a lawyer again. So as it stands, you have a bond of $500. I'm gonna look into the circumstances of your prior arrest, and if the bond order that Judge Knights gave you, if this new arrest does not violate those terms, then you'll be able to bond yourself out. Okay. All right. You're free to go back, Mr. Robinson. Okay, we're going to pause on the male side. We're going to go over to the female side with Miss Gomillion. Ma'am, you are what we call an add-on, meaning that you are not originally set for this schedule, for this calendar, but there was a request made for you to be placed on this calendar, so you can be heard today. You're charged with one count of criminal trespass. The bond is going to be set at $3,000. Do you believe you can post that bond? And that's through a bond spelsman, cash, or through property.
My mom can probably,
I'm sorry, ma'am.
my mom can probably do
Okay, and your mom is Danita Gomillion?
it. Yes, sir.
Okay. She's gonna have to go through a bonding company. I've placed a stay away provision on your bond to stay away from Danita Gomillion.
That's my mom.
I understand, ma'am. But let me explain something to you. As a judge, I don't have the time or ability to stay at your house to judge what's going on. And as a community, we don't have the time or resources for police officers to be brought over to your house. I know you're fairly young, but you need to understand that actions have consequences. Okay? So just because she's your mom, we can't, from a public safety standpoint, say, well, okay, just do what you want. Just go ahead and, punch holes in walls, tear up the house, do it, whatever you want. Because if your mom lets you do it, your mom lets you do it. The police were called out to your house, and that's a drain on resources. Because there are people that are getting their doors kicked in, there are people that are getting robbed, there are people that actually need that police officer or those police officers that went to your house. So you need to understand that even if this was just a minor incident, in your life with you and your mother, it has major impacts on the community and everybody else. So your mom can go through a bonding company to try to get you bonded out. Your mom can request from the solicitor's office for this stay away provision to be lifted or modified. But because I don't know you, I don't know your mom, we place stay away provisions because you're now eligible to be bonded out. And we don't want whatever disagreement that caused you to come before me today to reignite this evening. And then that's a further drain on resources where police officers have to come out to your home. You're going to have a preliminary hearing date set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Are you currently working, ma'am?
I actually just got fired like a week ago.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
If she doesn't bar me out, what happens?
If you don't bond yourself out or make other arrangements, you will be in jail until your preliminary hearing date.
Until December?
Yes, ma'am. Anything else, ma'am? Okay, you're free to go back. So that concludes the lady side.
Yes, Your Honor.
Thank you, Deputy Requena. Have a good day.
You too, Your Honor. Thank you.
Okay, are you Mr. Sandy?
Yes, sir.
Sir, you're charged with 1 count of trafficking marijuana. This is one of those cases where I cannot set bond. The amount listed for the marijuana was 58.5 pounds. Anything over 10 pounds, I cannot set bond. So bond is going to be denied at this stage. You're going to have a preliminary hearing date set for December 8th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for December 10th at 8:30 in the morning, courtroom 201. Do you plan on hiring your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
See if I qualify.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, you're free to go back. Mr. Stapleton.
Sir.
So you're charged with 1 count of theft by receiving property being a motor vehicle. Bond's going to be set at $10,000. 1 count of obstructing of an officer. Bond's going to be set at $2,000, and 1 count of driving a vehicle without a license. Bond is going to be set at $1,000. So that's a total bond of $13,000. Do you believe you can post that bond? I'm sorry?
Yes, sir.
Your preliminary hearing date is going to be set for December 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
You do qualify, Mr. Stapleton. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back. Mr. Taylor. Mr. Taylor, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
No, I cannot, sir.
Okay. There's going to be a stay away provision on the bond to stay away from, it looks like it says Alish Ratanani. Do you understand that?
I do not understand why I'm locked up. I don't understand why this happened. I need somebody to explain something to me. This is not right. What happened?
Do you understand the stay away provision?
I don't even know who the person I need to stay away from.
Yes.
The name you just said, they're not, I don't even know who that is, sir.
Okay, give me a second and I'll explain everything to you. You're gonna have a preliminary hearing date set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond yourself out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please, sir. Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Now, the allegation reads as such. It says the above date and time in Clayton County, which would be yesterday. The offender, which will be you, committed the offense of criminal trespass, unlawful purpose, in that you were alleged to knowingly and without authority enter upon the premises of Chevron gas station located at 64 Tar Boulevard, Jonesboro, Georgia, for an unlawful purpose. This is in reference to case number, and they put down 210-60783 to the offender being criminal trespass from the address on October 26th at, says 0611 hours. So that's 6:11 in the morning. Video footage was obtained of the offender on the property after he was criminal trespass. This incident occurred in Clayton County. So I'm gonna change this bond to $1,000. Okay,
So much, sir. Thank you.
so do you understand now, sir, why you were arrested?
I kind of do, I understand that I came on the property when I did not supposed to be on the property.
I'm sorry, can you repeat that?
I understand that I should not have been on the property.
Okay, so the basic allegation is that you were told that on October 26th not to come back on the property, and they're saying they have video footage of you coming back on the property after you were told to stay off the property. Okay,
Yes, sir.
anything else?
I just want to get out so I can try to get my life back.
Okay, and stay away from that Chevron gas station, because if you go back, you're gonna get arrested again.
I understand that's the only way that I have to pass that way to go past my house. That's the only reason they probably had the footage. I got to pass that way.
You do not have to go onto the property.
But I have to pass that street. Oh, that's not what they you all.
Mr. Taylor, do you understand the difference between walking down a sidewalk and walking onto someone's property?
Yes, sir. Yes, sir, I do.
Walk down the sidewalk.
There's no sign on that side, so I have to, if I had to cross over the street to go to the U-Haul, it would be better, but I do understand, sir. I do.
All right, generally there's a buffer that's considered public property for every roadway. That's about 5 feet from the roadway.
Mhm.
Don't go onto the property. Don't use it as a cut through. Don't, because, sir, if you do that again, you're gonna get arrested. So I don't know if you prefer spending a night in jail every now and then, or you prefer going about your business, but it's up to you. Okay. All right, you're free to go. You're free to go. Tell me your name, sir.
Tracy,
Okay, Mr. Aldridge, sir, you are here on what's called a fugitive from justice warrant. And what that means is that simply that there's a warrant for your arrest out of another state. And in your situation, there's a warrant for your arrest out of Bradley County Sheriff's Department in Cleveland, Tennessee. And the allegation is for larceny. Has anyone spoken to you about this process?
As far as, no, sir.
Okay, so you, as a fugitive from justice, Clayton County has no interest in your case. We have no interest in your guilt or innocence. We don't make that determination. We are holding you pursuant to an interstate compact where we would hope that if there's a person that has a warrant pending out of Clayton County and that person is arrested in Cleveland, Tennessee, that they will hold that person so that Clayton County can make the determination as to where it wants to go and retrieve that person or not through extradition. In this case, Cleveland, Tennessee has said that they will seek your extradition. You, if you believe that you're not Tracy Lynn Aldridge Jr., or if you believe that there's not a warrant pending for your arrest for larceny out of Cleveland, Tennessee, you can challenge this warrant. And if you say you want to have a hearing, which is basically called a writ of habeas corpus hearing, sometime between now and 90 days, there'll be a hearing in this court. And the only thing the judges are going to judge will determine is whether you are the person named in the warrant and whether the warrant actually is for a crime. If the judge makes that determination, they will sign off on the governor's writ, meaning that you can be extradited to go back to Tennessee. And Tennessee will have an initial statutory period of 30 days to come and get you. If they do not come and get you within that 30-day period, they can request an additional 30 days. So it's a time period up to 60 days that they will have to come and get you. If they don't come and get you, then Sheriff's Department will release you out of the front door. But being released doesn't make the warrant go away. So if you run into law enforcement officer 5 minutes after getting released from the jail, and that person runs your information and sees that there is a valid warrant for your arrest or pending warrant for your arrest, you will get arrested and the process starts all over again. If you believe that you are the person named in the warrant, and that if you believe there is a warrant for your arrest for larceny out of Cleveland, Tennessee, you can waive that writ of habeas corpus hearing today. And then that 30-day clock begins to run today. I generally tell people that, one, you should get you a lawyer to represent your interests up in Tennessee, because I've had people who've appeared before me that go through this process. They hire a lawyer and the lawyer works on their behalf in the other jurisdiction, and the other jurisdiction actually grants a bond, because during this pandemic time, they may not want to come to Georgia to come and get you, or they may not want to spend the money to come to Georgia and to get you. When you hire a lawyer and the lawyer is up there advocating on your behalf, they understand that you're taking this seriously. And I've had situations where persons have signed the waivers, and then a week later, I get an order saying, hey, this person has a bond.
Can I ask you a question? When you say get a lawyer, should I be getting a lawyer from Cleveland, Tennessee? Is that what you were saying?
Yes, sir.
Okay.
Because we can't, in Clayton County, a lawyer here can't do anything for you. I'm not going to grant you a bond over what goes on up in Tennessee. but I will adhere to whatever Tennessee decides to do. And the sheriff's department will also. If the sheriff's department gets the information to release you, they will release you because it costs us money to house and clothe and feed you. And we don't have any interest in your case. Yes, sir.
That's another question. How would I go about getting a lawyer from Cleveland, Tennessee? Would I just have to get on the phone and call my people that's still outside and see if they can help me out with that?
That's the best course of action. Have you ever had a lawyer up in Tennessee?
No, no, sir.
Okay. So either you or someone from your family, do you have family in Cleveland, Tennessee?
No, sir.
Okay. So if there's a lawyer that has a license out of Tennessee, that lawyer can represent your interests. So that is always the best course. I'm a judge, I'm a lawyer. And if I was charged with a crime, the first thing I'm going to do is get a lawyer.
Okay.
So do you have any thoughts or questions as to whether you want to waive the hearing or have the hearing?
I guess my question would be, what would be the best course of action for me, as far as trying to get out as soon as possible, get back to working and everything.
Well, if you're trying to expedite this process, the waiver route is the quickest because, like I said before, it could be up to 90 days before there's a hearing if you want to have the hearing. So you'll be sitting here waiting on the results of the hearing. And by and large, I don't think I've ever seen a situation where a person was not eligible to be sent back to the other jurisdiction. So if you're sitting here for 90 days and a judge signs off on your going back to Tennessee, if they go through the first statutory period of 30 days, now you're at 120 days, which would be 4 months.
In jail?
Yes. Here in Clayton County, before you even get up to Tennessee to start dealing with this.
Yeah, I think I'm gonna sign the waiver.
Okay. So the deputies will give you the paperwork to sign. And once you sign the waiver, they'll send it over to me and I'll sign it. And the clock will start to run today. But I would encourage you to hire a lawyer
Yes, sir.
up in Tennessee to represent your interests. Okay. Okay.
Thank you.
You're welcome. So we're done.
Yes, you are.
All right. Well, I'm going to close this down and
I just have one question. Because Mr. McCree has his TPO already, it was already served him, I don't think he said go and get him, right?
yeah, it sounded like he said that he had been served with it. And maybe we just didn't have the updated information.
That's what I'm thinking as well.
Yeah.
Because he had it in his hand.
Okay. Okay. Then he's been served.
Okay, okay.
All right. Thank you for your assistance. I'll see you tomorrow. Have a good day.